So once again, welcome to the legal framework, real estate. So in this lesson, we will unpack Land Use Act of 1978, dissect key title documents, explore survey plans, master rigorous due diligence protocol. So because in Nigeria, even the best financial analysis is worthless if your root of title is defective and faulty. So let's begin now. Slide 2. We have what we call jurisdictional authority splits between urban and non-urban lands. Okay, so I call it a jurisdictional matrix. So under the Land Use Act, land authority is divided between urban and non-urban areas. In urban areas, designated by the state governor grant a statutory right of occupancy. So typically for residential, commercial, and industrial use. But in non-urban areas, the local government council grants a customary right of occupancy, mainly for agricultural and grazing purposes. So this split shapes how land is allocated across Nigeria. Slide 3, please. So now in slide 3, we discuss about the states. Okay? That is, the state retain the ultimate power of revocation. Look at section 28. Now discover that this is a grant for revocation and grant rent warning. Never forget, the state holds the ultimate power. Section 28 of the Land Use Act empowers the governor to revoke a right of occupancy for overriding public interest. So, and this is valid grant when it comes to issue of controversy. And the valid grant includes the need for public projects like road or railways, development, any other thing that contradicts the approved master plan or critically breach of covenants such as failure to pay annual grant. Due diligence must always confirm that grant rents are paid up to date, and otherwise perfect title can be revoked over historic unpaid levies. Then caveat emptors via the move on to slide 4, please. The certificate of occupancy is the origin contract, not a permanent deed. So what do I mean by that? What I'm actually saying is that the certificate of occupancy, that is CFO, is the origin contract, not a permanent deed of freehold ownership issued by the state governor or FCT minister. It evidences a statutory right of occupancy, usually for 99 years leasehold terms, and includes specific covenant on use and development timeline. So the important myth buster here is that a CFO is issued once per parcel. When the vendor sells, you cannot simply take their physical CFO. A new transfer process involving governor's consent is legally required. So, and this is a message for any one of us who wants to buy a parcel of land that has a CFO. So, before the CFO can be transferred to you, it must require governor's consent. Please take note of that. Move on to slide 5. So section 22 of the Land Use Act is crystal clear. That is, any alienation, sale, mortgage, or assignment of statutory rights without governor's prior consent is void. So the legal chain is straightforward. Vendor holds the CFO, Governor Consent Act as the essential legal bridge, and buyer receive a registered deed. While official guidelines target 30 days, real world processing in places like Lagos, Abuja, and Port Harcourt often takes 3 to 6 months. Always budget for governor's consent as a mandatory closing consult. So I'm still discussing about the transfer of ownership here. So the transfer are only legally valid if there is governor consent on it. So you must be aware of that. Let's move on to slide 6. So in slide 6, we discuss about bypassing consent triggers cascading legal and financial failure, right? So this implies that bypassing governor consent triggers serious consequences. First, the entire transaction is void ab initio. Okay, that is, the buyer acquires no legal title and protection against third party. Then second, asset becomes illiquid, you cannot legally resell it. Then thirdly, bank will reject it as collateral, no mortgage or loan value. Fourth, you face revocation risk with the state potentially imposing penalty, blocking the underlying right of occupancy. So never skip this step. This is a red line for everyone. So when you are buying a land that has C of O, must have governor's consent. If you fail to do that, use those things I've mentioned. Then move on to slide 7. Slide 7, that's survey plan define the physical reality of statutory grant. While the C of O prove the legal rights, the survey plan defines the physical reality. A registered survey plan establishes precise boundary, guns, and coordinates to prevent dispute. So you need to verify the exact square meterage, and through charting confirms the land is not in a government acquisition zone. Provisional survey are for preliminary checks only. Only registered survey lodged with the Surveyor General carry full legal weight. Always verify before you buy. Okay? Then slide 8. That's the diagnostic matrix comparing the 3 pillars of title. So let's look at it. You think of a valid title as resting on 3 pillars. The certificate of occupancy is the origin lease grant from the governor. So governor consent legalizes any transfer, and the registered survey defines the physical boundary. So if any pillar is missing or defective, the risks are severe. Effective root of title, void transaction with no collateral value, or even demolition without compensation. Use this diagnostic matrix to stress tests every day. Let's move on to slide 9. Due diligence requires both documentary verification and physical grant truth. What do I mean by that? That is, effective due diligence combines documentary checks with on-ground reality. It has 4 quadrants. Phase 1, we have registry search for root of title, encumbrances, and ground rents. Then phase 2 has to do with cadastral charting to check overlaps and acquisition status. Then we move on to phase 3 on Maunile intelligence through site visits, caveats, and community inquiries. Then phase 4, legal history review via the epitomes and abstract of title. So in Nigeria, caveat emptor applies fully. Law does not protect an uninvestigating buyer. So location matters. Registry versus feed is very important. Then we move on to slide 10. In phase 1 and 2 that I just discussed just now, verifying the registry and charting the coordinates. Very important. Okay, so in phase 1, conduct a registry search at the State Ministry of Land. Then trace the root of the title. Identify any registered mortgages or liens. Check the residual lease. Lease term ideally. Okay, most of the time it's either 70 years or more than that. Okay, to know the remaining and confirm ground rent payments. So you will receive an official search report in phase 2. Take the survey plan to the Surveyor General Office for charting, overlay it on the master plan to ensure no acquisition, no overlap with other title, and no placement on highway or drainage zone. Skipping this has led to demolished structures with zero compensation. Then we move on to slide 11. Phase 3 and 4, gathering human intelligence and reviewing the legal chain. That's the site intelligence. So in this phase, bring human intelligence, visit the site in person, and never rely solely on map or videos. Look for caveat sign, possession notice, or court order. Discreetly speak with neighbor and locals about any family dispute or youth harassment there. Then in phase 4, this involves the epitome of title, a chronological bundle of all documents and the abstract of title, which narrates how ownership passed to the vendor. Your solicitor must review this for gaps. Okay? Together, these phases complete the picture. Then you move on to slide 12. So in this phase, follow this 7-step protocol before deploying serious capital. Okay? Number 1, engagement independent counsel. Experience the specific state. Let me take it again. Engagement independent counsel. Experience in this specific state. Then number 2, obtain formal registry search reports. Then 3, commission independent survey and charting. Number 4, have your solicitor review the epitome for a clean chain of custody. Then 5, conduct physical site inspection and community interviews. Number 6, you verify the vendor's identity. Be the national identity BVN or CAC status for companies. Okay. Then number 7, draft the contract with condition for vacant possession and governor's consent. So this flight path protects your investment. So we move on to slide 13 now. Regional framework, that is how Nigeria compares to key African markets. Nigeria operates a leasehold system under the Land Use Act, with no true freehold rights are granted by the governor or local government. Compare this regionally. Ghana uses a mix of customary and state system with registration at the Land Commission. Kenya employs Torrens title, the more digitized National Land Commission, and recognizes freehold. South Africa follows Roman Dutch law with recognized freehold across Africa. So the universal rule hold, and unregistered interests remain vulnerable to extinguishment. Registration is paramount everywhere in Africa. Okay, so move on to slide 14, which is the last slide. I titled it Essential Heuristic for Navigating Nigerian Property Markets. 4 key points with seals. So to close this slide now, remember these 4 essential heuristic. First, embrace the leasehold reality. Hold a maximum 99 years right of occupancy as a trustee, not perpetual freehold. Second, consent is the only valid transfer without governor's consent. D is legally void with zero collateral value. Then third, check before you buy. Always overlay register survey on the surveyor general's master plan to confirm it is free from acquisition. Then number 4, trust nothing and verify everything. Caveat emptor demands independent counsel, street searches, and active ground intelligence. Apply these rules and you will navigate Nigerian real estate with confidence. So with this explanation, I believe I've been able to explain to you how you can navigate through Nigeria legal system, okay, as related to your land and property. Always ensure that all those things mentioned in this lecture are followed. Ensure you verify before you make your payments. Thank you. God bless you.